Good morning, everyone. Welcome to Taylor Wessing's webinar on the FCA's Business Interruption Insurance Test Case. I'm Katie Chandler, a partner in Taylor Wessing's Disputes and Investigations team, and I'm joined by Julian Randall, another partner in the team.
Hello.
Julian and I have been closely involved in the FCA test case relating to business interruption insurance claims through the work that we've been doing for UK Hospitality, which is the trade association representing hundreds of hospitality businesses, and they've been working very hard to lobby the interests of the sector during what is a very challenging time. We've been involved in advising members on their business interruption policies. We've made some submissions, previously made submissions to the FCA in support of the test case that they brought, and separately we are representing other clients in bringing claims against their insurers. Today we're going to speak for about 45 minutes and give you a bit of a background on what the FCA test case was all about, and a summary on the judgment that was handed down last week, and then we'll have some Q&A at the end. There's a chat bar, so do feel free to put your questions in there. So the much anticipated landmark decision and the first ever case to be determined under the Financial Markets Test Case scheme was handed down last week on the 15th of September, and that's what we're here to talk about this morning. So just a bit of a recap on what the test case was. It was the FCA stepping into the shoes of the policyholders. They brought a High Court test case against 8 insurers, including Hiscox, RSA, QBE and Zurich, and the plan and intentions was to seek certain declarations on the interpretation of policy wordings for business interruption cover. They were taken initially from a sample of around 17 wordings, and that went up to 21 during the process in which the FCA took submissions from various interested parties. And those were the policy wordings that the FCA said had sufficient ambiguity to warrant clarification and input and judicial guidance from the court in order to provide as much certainty as possible on how insurers should handle the business interruption claims. There was an expedited trial in July which lasted 2 weeks and was conducted over Skype, and it was all conducted very swiftly. And the FCA estimated that in addition to the 21 sample policy wordings, another 700 across 60 different insurers and around 370,000 policyholders could potentially be affected by this test case. So what is business interruption insurance? Well, traditionally it covers loss of revenue or profits suffered from physical damage to property. So that's usually incidences like a fire or a flood. But there are, however, some policies, and they are fairly common, which contain extensions for non-damage to property cover. These are known as, and have become known in this FCA test case, as the notifiable disease cover, the prevention of access and actions by a competent authority, and then hybrid wordings where you have cover that is a mix of both the notifiable disease and the prevention of access. These were the wordings that were tested in the test case. The court was asked to look and interpret in the usual principles of contractual interpretation as to what precisely the wordings in these policies meant, and in particular whether or not there was cover to provide compensation for the significant losses that obviously a number of businesses have suffered as a result of COVID and the government's response to it. And as part of the test case, the court was also asked to consider the application of trends clauses, which are often found in these policies. These affect how the claim is quantified and usually allow for certain trends in the market or in the economy that have impacted the business and would have impacted the business in any event, notwithstanding the insured peril that may have occurred. This was a key issue in the test case, and we'll come on to talk about that shortly. I think what came as a real surprise for everybody when the FCA initiated and brought their claim was that they put it forward on behalf of policyholders entirely and in full support of their position, and put forward sort of all manner of arguments to the best of their advantage. There was no neutral position, which is quite unusual given the FCA's position as a regulator. And their approach was ambitious, it was robust, and as I said, took many points that could be taken, and what I think many people in the market considered to be quite a bold move. The insurers, of course, responded by adopting a narrow approach, and argued that these policy wordings were meant to have a restrictive meaning and were not in any case intended to cover losses arising out of a pandemic. So we now have the judgment, and as I say, it was handed down last week. It runs to about 160 pages, so it is complex and long and actually quite difficult to follow. It is on the whole good news for policyholders and those sectors who have been very directly hit by the pandemic. And we'll come on to talk about the findings shortly. But one thing to just say from the outset is that it is focused on the precise wording of these policies, and particularly the definition of the insured peril, the insured risk. So as a result, there's a number of different decisions which have been reached by the court in respect of different insurers and different policy wordings. So this does mean that whilst we can talk today about the high-level findings and the key themes that have emerged, it really is important for those policyholders who, consider that they might be impacted to assess this decision and the judicial guidance against the policy wordings, because some policy wordings will respond, but others won't. And as I said, we can't sort of go through all of that today because we would be here all day. But on the whole, we do expect a large number of policyholders to benefit, and we'll come on to talk through some of the high-level themes that have emerged. And another point I think to note before we get into what was found is the FCA were not bringing a claim against the insurance industry which was resulting in any payouts to policyholders. The court wasn't asked to consider the case of individual policyholders. There were no questions around specific quantums or payments that were being sought by policyholders. But that said, it's a construction, it's a contractual interpretation, so we now have guidance and judicial decision on what the wordings in the policies mean. It's legally binding on those 8 insurers that were involved and in respect of the representative sample wordings. So if you're a policyholder with one of those policies that has been part of the test case, then you will be impacted. It is also important that it will provide persuasive guidance on the interpretation of similar policy wordings. And I think the FCA and the court and the insurers all fully anticipate that the decision here, and we'll come on later to talk about the impact of any appeal that might be on its way, will likely impact not only those policyholders with policy wordings that were part of the test case, but also those who have similar wording. So it has really significant impact and wide application to the market. So just to recap, everyone I'm sure on the webinar today will be fully aware and who can forget the events that happened in March 2020. But there are a couple of key time dates that were essential to the legal analysis as to these losses and significant losses that were suffered by businesses as a result of the actions taken. So just very briefly running through them, we know that from 22nd of February, COVID-19 was made a notifiable disease, and that's very important for the application of the disease cover. We had, on the 16th of March, Boris's speech to the nation, which was very much advisory, telling people to stay at home, don't take any unnecessary travel, and work from home where you possibly can. And key at that point, advising the public to avoid social venues. And then you get the legislation that comes into force that has legal effect and leads to mandatory closure of these types of businesses, and that was part of the regulations that were passed on the 26th of March. And what the FCA did in the test case was they categorised all the different types of businesses of whom they knew held these business interruption policies, and put together some assumed facts. And then there was a joint list of issues that was agreed between the FCA and the insurers around how these businesses were affected by the different types of action and both advice and mandatory orders taken by the government in response to the pandemic. And that's important when we come to talk shortly about the prevention of access cover. So just really broadly speaking, the key questions in the FCA test case were, is there cover in principle under any of these relevant non-damage insuring clauses in respect of the losses arising as a result of interruption or interference with the insured's business by the pandemic? Those key clauses, as I said, are the disease cover, the prevention of access, and the hybrid clauses. And then in principle, where coverage is established, can the policyholders establish the necessary causal link between those losses and the relevant incident, event or circumstance that is covered. And Julian will come on to talk about that in a bit more detail later on, about how the court looked at causation and the application of the trends clauses. So as a summary, before we get into some more of the detail, the court, as I said, it's good news. They ruled in favour of the FCA and the policyholders on a number of the key issues. So we do think that a large number of policyholders who have these policy wordings will benefit from the findings, subject to any appeal, which we'll come on to talk about shortly. But it is important to note that not all policies will be covered. And as I said, the court was very keen to emphasise the importance of the precise wording of the policies. We've got mixed findings. Certain insurers with certain policy wordings, the court says should cover losses for COVID, others absolutely not. And generally speaking, the disease cover came out more favourably than the prevention of access, and we'll come on to talk about what was said in a moment. But there was good news on the trend clause, and Julian will talk a bit more about that, but in short, the court did not think that insurers should be penalised for those losses that were inevitably going to be suffered as a result of the wider impact of COVID, what 2020 would have looked like anyway, with the sort of economic downturns as a result of the social fear, the sort of reluctance to go to these venues, particularly hospitality venues. The court said that's not going to apply here. What we're going to look at in terms of quantifying your loss is what your 2020 and your summer 2020 would have looked like without COVID, which is obviously very helpful. I don't know if you want to add anything at this point, Julian.
No, well, I think that the trends clause is a very important point, because, as you say, that there are two issues here. One, do you have cover? And two, is it worth anything? And the closest we have to legal findings of legal principle are in this area of causation. Okay, I've theoretically got some coverage, but does it mean anything? Or is the insurer going to maintain that I've suffered no loss which falls within the policy? And the court made, we'll touch on it lightly because they managed to sideline it, but they made very helpful findings in relation to the general law of causation in business interruption cases, but also by broad and constructive, we would say, interpretation of actually what the clauses meant, was able to pull larger losses into the cover. But I'll explain it further in a minute.
Yes. And I think it's important to say as well that the court made it clear that each business interruption policy is a contract, and the positions adopted by the FCA and the insurers obviously differed on this point, because the FCA were arguing that a lot of businesses that took out this business interruption insurance were small and medium-sized businesses. They were not necessarily businesses who had a huge amount of knowledge in relation to insurance and in relation to business interruption insurance. In particular, they relied upon advice from their brokers, or they relied upon what was told by the insurer. It's a fairly technical area, but they had thought they were purchasing something that perhaps it turned out wasn't as wide enough to cover what they had hoped. And then, of course, the insurer's position was that this is a contract and that this is clear, and that you need to look at the terms of the policy as a whole, because when you take it all together, the general position that was taken by the insurers and has continued to be taken by the insurers is that these policies were not designed to cover pandemics, despite the fact that there were no express exclusions for pandemics. But they argued that these were all designed to deal with particular localized incidences or localized outbreaks of disease, in which your premises might have been temporarily disrupted and interrupted, and it's those type of losses that you suffer there that the insurance is covering, not a full nationwide and global pandemic, but nationwide response that couldn't be pinned down to one specific incident or one specific occurrence of a disease or a closure, because it was all part of the overall response. And what the court did was apply the established legal principles and well-established tested principles on looking at what a reasonable person who has all the background knowledge could reasonably have been available at the time of the contract, what they would have understood these wordings to mean in the policies. looking at the ordinary language used and looking at certain circumstances surrounding the contracts. And this ultimately is an objective assessment, looking at the words used in the contract as a whole. So we'll come on to the findings, and the disease cover first. These are provisions which provide for cover for business interruption following notifiable disease, usually occurring within a specified radius or within the vicinity of the insured premises. I think it's important to note at the outset that the FCA, when it was putting together its test case, had sifted through vast numbers of policies and had made a decision at that point which policies and which wordings had sufficient ambiguity to justify the intervention of the court. So in that regard, there were certain policies in the disease cover that were not put forward in the test case. Those were the policy wordings where you have a list of specified diseases, and COVID is obviously not in them in that list, and so it's a closed list, and there could be no ambiguity that in this instance losses for COVID could apply. And then secondly, where you have narrower clauses that provide for business interruption that occurs from a notifiable disease, which is at the premises. And there's been a lot of debate, but we haven't really got time today to talk about that because that's another point, but that has been excluded. And I think that's on the basis that it's pretty clear that the wording there means that you're looking at the occurrence of the insured peril, whether it be the notifiable disease or some other sort of action taken, that it's at the premises and it can't have a wider application. So those were out of scope, and what we were dealing with here was the key point around the specified radius, and the most commonly used wording here was within 25-mile radius. And as I said, whilst it is necessary to look at each term and each policy wording, you could see that there were similar questions across the different policy wordings for disease cover. And really one of the key questions was, can it be said that those matters that led to the business interruption, which here is the government measures, that in response to COVID, would they have happened even without the occurrence of COVID within the radius? And does it have to be triggered only where, there is a case within the radius? The court took
So broadly what was happening here was that the insurance industry said we don't cover pandemic, which is clearly what they would have intended, because the insurance industry can't cover the whole economy for a pandemic, because that's not how insurance works. Insurance works by pooling the risk of all of us, and then the unlucky few who have a problem get paid much more out of all those premiums. And their position would have been, we can't pay for a pandemic. And you look at these policies and they say, we will pay you if you have to suffer a problem which happens locally. That obviously is meant to mean if you're one of the unlucky ones doing something peculiar to you happens, which is bad, then we will pay out for that. And I think that's what those policies probably were intended to mean, at least by the insurers. The problem is that it would be the easiest thing in the world for the insurers to say, by the way, we put an exclusion in, we don't cover for the effects of a nationwide epidemic or something like that. And they didn't do so. And they may have not done so because they forgot, or they may have not done so because they didn't want to tell the insureds that what looked like great cover, if you have a disease, covers you, that doesn't in fact do it. But that's turned out to be quite a big error, because the court, looking at all this, has now said, do I think that disease manifesting itself within 25 miles of the premises means the disease only manifests itself 25 miles from the premises, which in itself and only that causes the interruption, or could it mean there's a problem caused by that disease, and that disease also occurs within 25 miles? And they chose to take the second of those constructions, which is perfectly possible, but not, I think, what the insurers had in mind when they drafted the policy. And the approach the court has taken here is obviously to say, I don't really care if this is a consumer contract and I should be nice to the insured, or whether the insured actually had a broker and can be taken as expert, or what people's intentions were, what their secret intentions inside their heads were. And let's just look at the words on the page. And then I think they chose to be a little bit generous to the insured, the policyholders most of the time. But that is a distinction, is when is something so obviously local to the premises that it doesn't cover this general pandemic idea. And I think Katie and I both found the distinction between some of the policies which were covered and some which weren't slightly slippery, because you can't find a bright line between them, which is why, as Ed said, as Amy said, one needs to look very carefully at each individual policy, I'm afraid. What we can't do in this talk is find the one golden principle which runs through it, because the only golden principle is look carefully at the wording.
Yes, but by and large, as you say, Julian, the court adopted the FCA's interpretation, and we'll come on in a moment to talk about two that were treated slightly differently. But I think part of where the court was coming from was, this idea about what was the sort of meaning of the words, and the insurers were making the case that what would be the effect of this 25-mile radius provision if you didn't have an interpretation that it was only covering losses that were arising as a result of something local, and that that would just be arbitrary and a tick box condition for the cover. So the court disagreed and said, look, we'd have highly anomalous results here, because there'd be no effective cover if the local occurrence were a part of a wider outbreak, and where precisely because of the wider outbreak it would be difficult or impossible to show that the local occurrence made a difference to the response of the authorities in all public. So it's this point about the distinction between, how can you distinguish where you've got, certain number of people within the 25 miles and outside of it, and what's the what's really causing the interruption here? Is it that local case, or is it the broader pandemic? That is good news, because I think the court really did say that this is a disease that, like SARS, it was contemplated that it would be something that could start local and then would very quickly spread very quickly and become a widespread issue. So insurers must have contemplated that something that could be in 25 miles is something bigger than it could be something as big as COVID.
Yeah, but that's exactly right. But what people on this call need to understand as well is that in cases like this, which are about policy wordings, can be very important, and this one is very important because so many people have been caught out by the lockdown. But of course, what the industry will do will be respond by changing all their wordings, or by putting in exclusions which deal with all of this. So many of you will have already seen, talking to your brokers, that the policies have changed or they have specific exclusions. So this is going to affect the industry in the future, because it will affect the way wordings are done. But what we will have is a set of policies which probably do not provide for cover for the next pandemic, unless you sit down with your broker and say, look, I really want this cover and I'm prepared to pay for it. And in a hardening market, that could be quite expensive.
Yes. So just in short, summing up on the disease cover, very helpful findings from the court, which is basically that you're talking about one cause here of those losses, which is the occurrence of a notifiable disease, which was COVID, and the occurrence for the purposes of the policy wording is the outbreak of COVID. And even where you haven't got the 25-mile radius and you've got the sort of in the vicinity or near the vicinity wording, the court concluded that covers England and Wales, which I do think, Julian, I think is a little bit ambitious, but it's gone there and possibly might be somewhere where there's a point of appeal. But the court has construed it widely, because they said it was reasonable to expect that something like this sort of disease would have an impact on insureds and their businesses, widely, and so all occurrences of COVID-19 in England and Wales are, deemed as being within the vicinity, which, it was quite a surprising finding, actually. And then just on those two that cover hasn't been found, or at least it looks like in principle cover will be difficult to establish, two policies for QBE, and the court took a different view on this, because the court said that the wordings here were significantly different to the other disease wordings. What you had here was losses resulting from interruption or interference with the business in consequence of any of the following events, and then one being any occurrence of a notifiable disease within a radius of 25 miles, or some of the policies had 1 mile. Now, it actually wasn't the 1 mile that was fatal to the court's decision on the interpretation of this particular policy. It was the use of the wordings, loss resulting from the interruption with the business in consequence of an event. And what the court said, that the reason why that's different to the other wordings is that is clearly contemplating something happening at a particular time, in a particular place, in a particular way, and it's that event which is constituted by the occurrence of the disease within the specified radius, which must have caused the interruption. So there's a distinction there between, what is actually something taking place and something much more localised, and then the use of 1 mile just makes it easier to accept that the parties were contemplating that this was a specific and localised event.
Yeah, there was a very strange debate in this case about what is the causative relevance of a word like a phrase like following, or in consequence of, or caused by, and it was a sort of point only lawyers can get excited about, but actually a lot swung on it here, because the court was saying we have a nice, crisp, concrete peril, which is described as an event, not danger or emergency or disease. That's something slightly fuzzier, which could be wider than this particular event. So you've got something which happens very locally, and then in consequence of that event, you suffer a business interruption. And they felt that must mean that you had to show that your lockdown was caused by that local event. And clearly the lockdown wasn't caused by that local event, that was caused by COVID, but by COVID around the nation, which causes the government to respond. So, that is quite a fine distinction. The court felt it was with the FCA on most of these things, but when you had a nice, crisply defined peril and words like in consequence, it just pushed them across the line. But as I say, it's quite difficult to sometimes see the falseness of these distinctions, but that is how they were working it through.
Yes. And moving on to the prevention of access to the public authority wordings, the findings here were quite a lot more mixed, actually, and do require even more detailed assessment against the specific policy wordings, because the approach taken by the court here was far more restrictive and also sort of varying across the different insurers and the different policies. So these are clauses that are concerned with cover where there's been a prevention or a hindrance of access to or use of the insured's premises as a consequence of government or local authority action or restriction. Again, all the wordings are different, but some common themes emerged. And a key question for the court at the outset was, what the insured peril or the risk is and the extent to which that is triggered. So, as an example, you had an ARCH policy that says, we will indemnify you for reduction in turnover and increase in cost of working resulting from prevention of access to the premises due to the actions or advice of a government or local authority due to an emergency which is likely to endanger life. So a number of components to the wording of that particular provision. And the FCA were arguing that, a very broad approach, that the insured risk is the emergency, and the emergency is COVID. And the court disagreed and held that the peril here is the prevention of access to the premises, as a result of the government actions or the advice taken in response to the emergency, which is likely to endanger life. So you have to take it all in sort of component parts. And then you're breaking all down the different words, and you're looking at whether you've got clauses that provide for losses that result from action taken by an authority. I mean, it was pretty common ground that authority, be it government authority or local authority, I think there was one insurer, I can't now remember which one it was, that tried to argue that that didn't cover the government, that didn't meet much favour with the court. But it's common ground that that's the government action, it's the government response. So then the court had to look very carefully at what the policy wording was saying. Were we talking about advice here that had no mandatory effect, and that's why it's relevant and important to look at what actually happened, what the government actually did in those dates in March, some of which was characterised as advice rather than mandatory instructions. And then if you've got wording like action, which prevents access, then the court said that clearly has to have some sort of force in law, in the same way as you've got restrictions or imposed by an order. That's responding to a mandatory restriction. And then there you would distinguish between those wordings that there would cover only losses in circumstances where the business was actually mandatory required to close. So mere advice, the court said, didn't prevent access. It was only really the mandatory public health regulations that had that effect. Then the court had to look at, well, what effect did this have on the business? How do we actually look at the effect or the meaning of prevention? There's a lot of debate on a number of policies in the judgment around the distinction between prevention and whether that has to be absolute and has to be a complete closure of the business, or if you've got hindrance or only sort of partial closure, or what actually did the business do in response to the orders? Did the business close completely, or was the business able to continue but just in a reduced trading capacity? And one of the examples taken was in relation to a pub or a restaurant, for example, that already had a takeaway service prior to the government action, and perhaps offers in dining as well as takeaway, which most form quite a big part of the business. And whilst the government advice and regulations required that restaurant to close insofar as it couldn't do in-house dining anymore, they didn't necessarily require the restaurant to close completely to the extent that they could continue to provide the takeaway service. So in those circumstances, the court held that there wouldn't necessarily be prevention of access, because you're not prevented from accessing the premises for the purposes of carrying on that part of the existing business, which involved the takeaway service. But then there was a further distinction for those businesses who then set up takeaway services, because we obviously saw a lot of hospitality businesses do that in order to continue to trade. And where you've done that, you've taken a different step, because you've altered your business in response to the government actions and the government orders. And, that's a fundamentally different business to potentially is a fundamentally different business to how it's described in the policy. So then you're more likely to get within that sort of prevention and hindrance and inability to use wording. But again, we can't sort of today give complete clarity and confirmation on what will or will not be covered, because it very much depends on the wordings in the policies. And as Julian said, there was a lot of assessment on the application of words like danger, disturbance, emergency, and incident. Hiscox in particular had a lot of policies where you, and particularly in the non-damage denial of access clause, where you've got just a response to an incident. And I think, the court was pretty clear on the fact that these are, sort of referable to an event, again, something that happens at a particular time, at a particular place, in a particular way, and especially where you've got these incidences happening within 1 mile, it's much more akin to local incidences like a bomb scare or a gas leak or a traffic accident. And even when some of the wording talks about closures for more than 24 hours, so hindrance or prevention of access for more than 24 hours, the court said that doesn't detract from the fact that the incident is an event which happens locally, and it's quite common for access to be restricted for more than 24 hours, even when you're talking about something that's really just surrounding the neighbouring area. So, the court disagreed with the FCA that incident was synonymous with emergency or danger, and then if you don't have that extra wording about endanger life, it's more difficult as well, because they said, to be able to say that someone having a case of COVID in the radius, that being classed as an incident, they said for this type of clause is a misnomer and is really is going too far for the purposes of the business interruption insurance there. So very mixed in terms of how it looks for those policy wordings. And we have seen a lot of those policy wordings, and they are very common, particularly to hospitality businesses. So, I think we do consider those will be ones where it does require a closer look. Julian, did you want to add anything there?
Yeah, well, just to say, people listening to this call, this could have a huge impact on the value of your claim, because there are lockdown losses which are traumatic but can be offset to some degree by the furlough payments. But there's this long tail, and we're now seeing it's a very long tail of government actions which will inhibit revenue in lots of businesses, in particular probably hospitality. We were with the yesterday, but if you're in any doubt, look very hard, because it's one thing to be paid for the time you were locked down, but there may be months and months in which revenue is greatly reduced, and if your policy says interruption or interference, that's good. Or if it talks about denial of access or hindrance of access, that's good. And then you have to, I'm afraid, crawl through this thing, trying to find the best comparison to your wording, and probably, I'm afraid, talk to a lawyer. But don't give up on it, because that could be a bigger claim than any claim for the 3 or 4 months of lockdown. And we're thinking about it very carefully.
And then finally, on the wordings themselves, you had hybrid wordings. They came to be described as during the test case, and these were from Hiscox and RSA. They cover interruption to the business due to an inability to use the premises due to the restrictions imposed on by a public authority following an occurrence of a notifiable disease. So you have the blend of the two there. And really just, broadly speaking, the court rejected the insurer's case that these clauses only provide cover for losses flowing from a local outbreak, because they adapted the same reasoning as they had for the notifiable disease and disease covers. But you have to look at each sort of element and parts of the provision here, because you've still got the narrow meanings of restrictions imposed and inability to use. So again, as Julian says, very much depends on what impact that it had on the business, and where you fall within the meaning of prevention or inability to use here. And again, I think these are policy wordings that will need to be looked at closely. And actually, just as a sort of aside, and Julian, I know you've probably got a view on this as well, but there's been mixed reactions to this judgment, and it really does depend on which sort of side you fit. But Hiscox are, I think, actually quite relaxed by the outcome. They did have a pretty favourable finding on their non-damage denial of access wording, because it has been construed very narrowly. And again, the hybrid wording, it will be very sort of case specific, and we can see circumstances where it will still be quite difficult for policyholders. And I think they've lowered the estimates of what they think they're going to have to pay out on the business interruption insurance. And I think we certainly saw at the beginning that it felt like Hiscox were quite a big target here, because of the number of wordings that they had, and because of how potentially how broadly they could have been interpreted, and of course the response that Hiscox had. So if you speak to anyone there, they would have a very different view and take to what this judgment means for them.
Yeah.
Okay, so we will now, just for the last sort of 10 minutes before we come to questions, talk about what the court's findings were in relation to quantifying the losses, so issues relating to the trends clauses and causation. And we will try and keep it fairly high level, because this is where you get to the very sort of legal technical points and sort of intricacies of insurance law, and I'm sure people aren't here this morning to listen to that. So Julian, do you want to take?
Okay, yeah, sure. Yes, but business interruption claims are slightly unusual. I mean, most insurance claims are about something going wrong, often being broken, and therefore needs to be replaced or repaired, and it costs what it costs. What you're doing in a business interruption claim is saying, I've had to stop trading. In the period I stopped trading, I would have made all this money. Everything would have gone really well. And I would like you to reimburse me for my most optimistic and sunny view of what that future would be. What the courts, what the industry have done is try to reflect that reality, that one is looking at a projection as to what would have been earned in the period of lockdown, and say, well, let's try and work out what that would have been. So nearly all these policies will contain what's called a trends clause, which simply says, well, yes, you can't simply have what you had last year because the economy might have been better or worse than last year. There may have been problems at your business which would have inhibited revenue, or you may have made some investments in a period which means it will be better. Yeah, so the trends clause means what it says really. It's trying to plot what the trends are in the business, and that means putting in factors and taking out factors which the court thinks would have happened. And that can lead to some complexities, because the obvious problem here is that if you say something has happened, which means my business has been closed down, I am insured for the fact that the business was closed down. What would I have lost in 2020? Well, if in 2020 you would probably, in many businesses, not have earned much money, even if the government hadn't shut you down, because of the other effects of the pandemic. So if your cover is simply to close you down, closure, and not the pandemic, then what is the future you have lost? And this has been a problem in this part of the law for a little while. There's a case called Orient Express, which is a causation case rather than exactly about a trends clause, but it's the same effect. In that case, a hotel was damaged by Hurricane Katrina, and when they came to make their claim, the insurer said that Hurricane Katrina, you're just covered for damage to property. The year you lost was a year in which New Orleans was completely trashed by Hurricane Katrina. Therefore, you suffered no loss. And they won that case. And that's always been troubling for many people, including me. What the court did here is take exactly the same approach they took throughout this case, which is to say, let's look at the words. And they said what's important here is not so much the trends clause as what is the insured peril. And they say, if one can construe the peril to include COVID, then it would be madness to say that you can't then be compensated for your loss because COVID would have caused your trading to be worse. In other words, what the lawyers call a counterfactual should have COVID stripped out of it. And in relation to the disease clauses, they found exactly that. They said the disease, the trends, the insured peril is a composite of the inability to use the premises, the fact that it had been closed down by some sort of public authority or legal mandate, following a disease. And all those three factors are part of the peril. And then what the policyholder is therefore covering himself against is what the court called the fortuity of being in a position in which all these three elements are present. And the court said that they therefore thought it necessary to strip out all three interconnected elements. So that is very good news. If, of course, on construction, the peril is quite narrow, as in some of the Hiscox policies, for instance, then on construction, the composite peril does not include COVID, and so its effects will not be to strip out the effects of COVID. But in general terms, the court were very helpful, and I think it is a right approach. I don't think they were bending over backwards to help anybody. This area of the law has been tricky for a little while because, on the one hand, the insurers appear to be offering people compensation for the fact they've lost all this trade, and on the other hand, taking it away by saying, "Well, I think because that bad thing actually happened, you would earn no money, so you didn't give me any money." So I think it's an area where there may well be an appeal, but the courts have done their best to make it unappealable by focusing on the wording, which is rather than broad propositions of law.
Yes, and then that brings us on, thank you, Julian, to what this all really means right now for your business. Well, the court has told the insurers that they now need to go away, carefully review the guidance and the judgments on the interpretations of the various sample wordings, and contact all of those policyholders within 7 days who they consider to be impacted. But sadly, what this doesn't mean is the insurers acting quickly in potentially overturning decisions they may have made previously on rejecting claims. From the letters we've seen so far, they haven't really said much. They're holding the ring. They're telling policyholders that the judgment's been handed down. It's potentially subject to appeal. They're considering the judgment. And under the framework agreement that was entered into between the FCA and the insurers at the beginning, it made it clear that there would be no final resolution on this and on the ambiguities in the wording until all appeal avenues had been exhausted. So everybody is sort of all anticipating that there will be some points of appeal made by the insurers, and they will be leapfrogged to the Supreme Court and go straight to the Supreme Court. And all we know at the moment is that there's another hearing in October where the court will deal with making the specific declarations on the wordings, and that's just really, putting down on paper what they say each wording means and sort of taking it out of the judgment and having it in formal declarations, and also dealing with applications for permission to appeal. We think that there probably will be some attempts, maybe not by all of them, because it is very specific to the findings in each wording, but there may well be some appeals by the insurers, and also potentially the FCA and the Hospitality Intervention Group in respect of those two QBE policies that were not found to, in principle, not found to have cover for the disease, notifiable disease. So it's kind of a wait and see. We do have this judgment. It is very important. It has been much anticipated and will be welcomed by a lot of policyholders, but we now need to see what happens in the next couple of months. And all parties involved understand it has to be expedited. We have to move quickly. That was the whole reason for the FCA getting involved, because, businesses are in real desperate need of these payouts. So, we would hope and expect any appeal to be, to happen quickly, and for a final resolution of this potentially by the end of the year. Julian, anything to add before we go to questions?
I don't think so. No, thank you.
Right. Okay.
We have a quite difficult question.
Okay. So we've been asked what the court's interpretation was of immediate vicinity in relation to an incident closure by competent authority. So that's talking about the prevention of access and competent authority wordings. Actually, Julian, we didn't actually cover this, did we? But the court did take a different approach to vicinity in this context, didn't it, as opposed to the wider interpretation under disease cover.
Yeah, I mean, and that shows how slippery this is. Vicinity, they say, for disease cover simply means anywhere from which the premises might be affected by disease, which I think, as Katie indicated, rather empties vicinity of any meaning, because vicinity in that sentence is to narrow something by definition, but they may deal with England and Wales, which seems a bit strange. The wording which the question points to here is immediate vicinity, which in the context of, I think, denial of access clauses they felt meant something slightly different, which how slippery this can be. And the answer to the question is not easy to clarify, but they took a narrower approach, as Katie has said, to denial of access clauses generally. But without the context, it is quite tricky to say much more about it, unless you have a brilliant insight, Katie.
Yeah, no, I agree with that. So we've also been asked where you can find the FCA's longer list, and I think that's what I mentioned at the beginning, which is the additional policies that might be impacted. That's on the FCA's website. They have a dedicated page to the business interruption test case, and it's quite easy to navigate through, so you should be able to see there the link to that, and it is well worth having a look because they do name the policies and the insurers. And we've had another question: which insurance companies came out the weakest? I mean, that's a difficult one as well, Julian, isn't it? But, I mean, in terms of the disease wording, but in the disease wording, most of the insurers lost there. You had RSA, Argenta, MS Amlin, and you just had the two QBE who got a bit of potential victory there. And then in the prevention of access, Arch, I think there was the ecclesiastical was found not to have cover. But I think that was very specific to some of the types of businesses. Hiscox, I think, will again depends on the precise impact on the business. You had Arch, which had a slightly more favourable wording for policyholders because it had this emergency to endanger life, which I think was more helpful. But then you had Zurich, which had the danger wording or the disturbance, which was not found to have cover because, again, the court said that was clearly contemplating something local. And then on the hybrid wording, looks like no cover on the Hiscox incident wording.
But in general terms, it's almost a random distribution of awards, if you like. I mean, there wasn't any sense really in which a particular insurer was a bigger sinner than anybody else. This really is the court looking through a series of policies, none of which they thought were objectionable in themselves, and trying to construe a meaning, and I think helping out policyholders when there was a failure by insurers to say what the insurers probably meant, which is we don't cover pandemics. Looking at these policies, there are slightly different approaches. I think the use of the word vicinity is fraught with difficulty. If you can come up with a geographical limiter, it's probably a good idea to make it concrete rather than leave it to the court to decide what vicinity means. But I didn't feel at the end of this sort of a league table of good and bad insurers. It was simply people who happened to win on the particular lottery of this judgment.
Yeah. We've had a question: what would our advice be to policyholders at this point in time, pending the further steps appeals, in order to ensure that previously denied claims remain pending and not closed?
Well, if you haven't, you should certainly be maintaining your position, unless let's assume that your position is arguable and relevant to this case. Then, as Katie says, the letter we've seen going out is really the insurers just seeking to hold the ring whilst they decide whether they're going to appeal. I don't think it's certain that there'll be an appeal, but I think it's probably likely. And you should definitely not signal to insurers that you've given up your claim. In terms of quantifying a claim, one of the problems with business interruption claims, and it does depend on your policy limits, is that they are quite intricate often, because you are trying to judge in advance, to form a judgment as to what you would have earned in that period. And I like in these sorts of claims to involve loss adjuster pretty early, because they are quite complex. That's fine if you've got a very large policy limit. If you haven't, then it's money you don't want to spend until you've got some certainty. So for most smaller policyholders, I would say simply reserve your rights and try to gain as much certainty as you can before spending money on loss adjusters or lawyers trying to joust with the insurers. I think that this has been quite bruising for the insurers, although there are mixed messages coming back from the industry. But there will be a vast number of potential claims and not many loss adjusters. And the pragmatic way forward will be, I hope, for insurers to seek to cut a deal where people will take slightly less to settle claims early than the maximum value they can possibly put on the claim. But it could go the other way, and they could be very difficult. It's difficult to know. But unless you've got a big policy limit, I wouldn't be spending money preparing a claim now. I would see which way it goes and whether there's an appeal. But a simple reservation of rights is more than sufficient. In fact, not giving up your rights isn't sufficient. Silence is probably sufficient.
Good.
Okay,
well, last couple of minutes before we close, last opportunity for any more questions. Okay. Well, thank you very much, everybody, for joining us this morning, and hope you found it helpful and useful. And as we say, it's some further welcome guidance that we have here, but it is also another watch this space. But we hope that there'll be a final resolution to all of this in the next couple of months.
Very good.
Thank you very much. Thank you.
Bye.
Bye.